All right, so welcome everyone to this week's webinar. We're going to talk a little bit about the 88th legislation, the new updates that we have coming out of Austin this year. And we'll just go over a couple of the most important bills that we've seen recently that are probably going to affect our industry if they're passed. What we're going to do today is kind of go over some of the things that have been filed that may be correct, some bills that we've previously seen, and then some new things, and then some familiar things that we've seen as well. So let's go ahead and get started. The first thing I'll talk about is some key dates, some of which have already passed, but some kind of go into the remainder of the year all the way up until June, and then we'll get into the bills. So here are the key dates. First, we have, on November 8th, is when we had our general election for federal, state, and county officers. And you can see, as I mentioned, some of these bills have passed, but the bill file date, it opened on November 14th. Then the 88th legislative session actually convened at noon on January 10th. The last day to file bills has actually passed, so the deadline was on March 10th, which is actually a good thing, so that means we won't get any more surprises. Then the last day of the session is actually on May 29th. Then the last date that we should really be concerned about is June 18th. So that's going to be the last day for the governor to actually sign or veto any bills that were passed during the regular session. That's when we'll know what has been passed, what's really going to affect the Property Owners Association industry, and then we can kind of get prepared from there on out to, make sure everyone is updated with whatever comes out of this legislative session. So let's go ahead and get started. As we all know, SB 1588 really kind of turned the POA industry upside down in 2021. And there were a lot of things that were left unanswered, a lot of vague provisions that we weren't really sure how to handle. We kind of did it to the best of our ability, but of course a lot of the things that came up during the time between it was passed and now have not had an opportunity to really go before a judge and be adjudicated. And so we were just kind of left with all of these confusing aspects to SB 1588. Fortunately, there have been some bills that have been passed recently that have been submitted to the legislative session that would actually provide us with some clarity, which is a good thing because obviously, again, as I mentioned, there were a lot of questions from that piece of legislation, and we really need to, clarify quite a bit of it. A lot of the changes that I'm going to talk about, they apply to both condominiums and single family. Some of it applies to one or the other, and so I'll make it clear what applies to which type of community association. First, we're going to get into some corrections that would apply to condominiums. So first of all, one of the bills would add section 82.1142. The bill that I'm talking about right now is 1688, SB 1688, and then also HB 3503. These bills are both very similar. They kind of mirror each other, but it would add section 82.1142. So as many of you know, currently under Chapter 82, there is no requirement to have a publicly accessible website dedicated to the association and its governing documents, similar to what we saw come out of 1588 as a requirement for 209 properties. So this new section would be added, and it would make it a requirement that there was a publicly accessible website, and it would mirror that language that was adopted back in 2021 in section 207 for single family communities. That requirement would apply to condominiums that have at least 60 units or that are managed by a property management company, right? Managed by a management company. So we would be required to have this publicly accessible website. These two bills would also amend section 82.116 to require that management certificates now be filed with TREC and be posted on the association's website. This is actually really important because under this proposed amendment, if the association fails to file its management certificate with TREC, that means that a unit owner would not be liable for attorney's fees incurred by the association related to collection of delinquent assessments. This is a similar requirement related to single family communities, but now the same thing would apply to condominiums as well. And then finally, it would also amend section 82.157, which would propose a cap to resale certificate fees at 375, which is not currently one of the restrictions that we have, but this is something that was implemented for 209 communities back in 2001. So it really mirrors that language that applies to 209 communities, just to kind of make it a little bit more uniform. Another correction to SB 1588, which we actually love this correction. These two bills that I mentioned earlier would propose to fix a huge issue that we encountered with 1588, which was related to security measures. So one of the biggest unanswered questions after SB 1588 was passed was regarding language about perimeter fencing. It was very broad, very undefined language, and it was really just problematic because we didn't have answers to these very specific questions, especially back in 2021 when we were drafting policies related to security measures and perimeter fencing. We always had to give this disclaimer that basically, there's no case law or any prior adjudication regarding this issue. And the issue was, yeah, we understand that the association now could not prevent an owner from installing a perimeter fence, but we didn't know what kind of fence would be allowed, how tall it could be, what sort of materials this fence could be made out of. And then questions came up like, what happens if the fence blocks a sidewalk? What about driveway gates? And then another big question that kept coming up was, when we say perimeter, are we talking about a lot line or a build line? So this one is really something that we're happy to see. Now it's going to amend a particular section, particular part of section 202.023. And that's going to make it so, we're going to prohibit the placement of a perimeter fence that obstructs a sidewalk, a drainage area, or an easement. There will be certain requirements related to driveway gates. You can't install a fence that is in the front of the frontmost building line, so it makes that distinction between the lot line and the build line, and so on and so forth. So these are some really important corrections that we needed to make. I mean, it doesn't clear up everything, but it certainly helps in our analysis of perimeter fences, which is great. The next thing that is going to be corrected by these two bills that I just mentioned is some of the issues surrounding architectural review authority that came up in SB 1588. So in SB 1588 in 2021, we got the distinction that no board member can be appointed to the ACC and vice versa, right? But now we're going to have this requirement that, and obviously, this new provision was promulgated in section 209.00505C of the Texas Property Code, and it's actually going to reorganize this section a little bit. So obviously, 209.005C actually talks about that requirement, right? That a board member cannot also be on the Architectural Review Authority, or the ACC as we like to refer to it. But now this is going to split things up a little bit. So we're going to add sections related to the solicitation of candidates to the ACC, and it's also going to impose certain notice requirements that I'll talk about on the next slide. And so actually, before I go to that, so these notice requirements are important because not only does it make it so that the association now has to solicit ACC members, similar to the way that they would solicit perhaps a board member, a candidate for a board, but also there has to be certain notice requirements that are given if a person decides that they want to, run for this position on the ACC. And those notice requirements for the election or appointment of ACC members are going to be added in section 209.00507. So this kind of breaks up a little bit about the ACC, the review authority that was given to us in SB 1588. It makes things a little bit more clear, but not really. We still will have this situation where we cannot have a board member and an ACC be on the ACC, but it allows us for us to kind of go out into the community and solicit individuals who may be eligible to serve on the board. And it gives us an opportunity to have a little bit more wiggle room when it comes to finding members to serve on the ACC. That it's been a common problem that we've seen where a community has said, okay, well, we have people that serve on the board and they also serve on the ACC prior to this rule coming out. And then as a result of the rule, they didn't have an ACC at all. So now we can, kind of go out into the community and find people who would be willing to serve on the ACC, and that's a pretty big thing. One of the other corrections that we saw was relating to security measures again. This one is actually really important because while we saw that issue about not having all the questions answered about security measures, specifically talking about perimeter fencing, one of the bigger issues that I saw come up time and time again was where in the front of the property, or to the front of the building, can this perimeter fence be located? So SB 1363, this is going to be related to community associations that are single family only, would amend the provision regarding perimeter fences to allow an association to really have that ability to self-govern, right? It's going to add section C to 202.0232, which basically states that the association could adopt a restriction that prohibits perimeter fencing in the front of the build line if at least 75% of the owners approve it. Now, this is kind of a steep threshold, but it's better than nothing, especially when, for the most part, the pushback that we were getting was related to that front perimeter fence, right? This also does a really solid job of leaving the association's ability to self-govern intact, because instead of forcing the association to allow anyone to build a perimeter fence, it gives the community the opportunity to have a voice in the situation and be able to speak up and say, yes, we would like to have perimeter fencing, or no, we wouldn't. All right, and then let's talk about HB 3776, which is also another correction, what we're calling corrections to SB 1588. This one actually mirrors language in the bills that I talked about in the beginning. And so it would be kind of like a supplement or kind of a backup to the other ones. The language is exactly the same. So if one or the other one gets passed, we'll still be in pretty good condition because it will still add those corrections or those clarifications to SB 1588 that we so desperately need. All right, let's move on to some other noteworthy bills that we're keeping an eye on for either its positive or negative potential effects on the association. So HB 1367 actually talks about adding section 209.0059 to the property code, which would be entitled Recall of Board Members, and then also section 209.018 related to board member violation of chapter or dedicatory instrument. Now, I'm not sure if I think this one is problematic or not, but we'll get into it. But essentially, it's providing the community with the mechanism to recall a board member by petition of 20% of all voting interests in the community and a special meeting. Essentially, it would allow for this election that community members are requiring to be recalled. It would have to happen after 90 days of receiving the petition. Only one board member can be recalled per petition, and it requires a majority vote for recall. Now, if it's successful, the board member's position immediately becomes vacant, and then that position has to be filled by the other board members. So then that one, in conjunction with section 209.018, this section actually allows for a board member, for an association community member, to bring an action against a board member in JP court for violation of chapter 209 or for a violation of the association's dedicatory instruments while that board member was acting in their official capacity as a member of the board. Now, the thing about this one that's really important to note is that if a judgment is rendered against a board member in this type of situation, then that judgment could order the board member to be immediately removed from the board. The judgment could award damages incurred by the owner resulting from the board member's violation. And then it could also allow for those damages to be deducted from the owner's future assessments, which is actually kind of wild. So we're going to pay very close attention to this one. But this is kind of similar to the one that came up last year in 2021, which would allow a homeowner to sue the association in JP court. This one goes a step further because it's allowing for an individual board member to be sued in JP court for a violation incurred during its official capacity as a board member. All right, HB 1786 talks about the association's ability to adopt or amend certain restrictive covenants. Now, this would impose certain notice requirements on an association if they were to adopt or amend a new restriction or some sort of amended restriction. So that the association now has to give 60 days notice before it's able to actually enforce that new or amendment to the restrictive covenants. One of the requirements, and these notice requirements are really strict, but one of the requirements is that the notice of the new or amended restrictive covenant would have to be published once a week for 2 consecutive weeks in a newspaper of general circulation in the county. And then it also has to be sent by certified mail to all of the owners in the community. I've not seen really for this type of situation that the new or amended restriction would have to be published in a newspaper. So this might be a little cumbersome, but it is one of the requirements under this new provision of the property code. And then also this new section of the property code, which requires publishing in a newspaper and for notice to be sent by certified mail, would also be added to section 209.0042 of the property code, which talks about how the association can adopt alternative methods of providing notice to owners. So HB 1786 is just proposing to amend this section to add the requirements from 202.0045, which would also be a new section of the property code. All right, so 1799, HB 1799 talks about the association's ability to regulate street parking of certain vehicles. Now, this bill, which applies to single family and condominiums alike, would prevent the Property Owners Association from adopting or enforcing provisions in their dedicatory instruments that might have the effect of prohibiting an owner from parking certain vehicles on the street adjacent to their dwelling. So these vehicles would include a homeowner's vehicle that's owned by the state or that's operated by the owner in their regular course of their employment, or that's required by the owner's employer to be parked in an immediate vicinity of the owner's residence, which is probably like an emergency vehicle or something like that. Now, this bill will require an adjustment in a lot of communities, which currently have provisions prohibiting street parking for a certain period of time. It's essentially creating an exception for work vehicles, and I could totally foresee a ton of huge work trucks, moving trucks, et cetera, clogging up the streets and preventing the normal flow of traffic. So this is one that we're really going to make sure that we pay a close attention to, because if it's passed, then we're going to have to change up a lot of our parking policies and just the way that we look at parking in general, because I know, for a lot of our clients and a lot of the associations that you all manage, parking is a huge issue. We get a lot of deed restriction violations related to big, huge trucks that are, in the street blocking people's driveways, preventing other homeowners from parking in front of their own properties, so on and so forth. So this one is something that may potentially pose a problem. So let's talk about HB 998 and SB 741. These are similar. This bill would amend the insurance code to permit the Department of Insurance to include in its Fair Access to Insurance Requirements Plan the delivery of POA insurance in underserved areas if its commissioner determines that the POA's insurance is not reasonably available in the voluntary market to a substantial number of insurable risks. So this is actually pretty solid, right? It's providing insurance to those underserved areas that may not otherwise have access to insurance. Now, this bill also defines property owners association insurance to mean property and liability insurance covering common areas and facilities of a homeowners association or a condo association, so it applies to both. Now, if the commissioner in this situation were to make a determination of unavailability, then it would require insurance to be made available to each applicant in an underserved area if their property is insurable in accordance with the reasonable underwriting standards, but they have been unable to otherwise obtain property owners insurance through the voluntary market. So this would help property owners associations to obtain necessary and required insurance coverage if it's not able to otherwise on the voluntary insurance market. So this one is actually really, really good. And I think this would make a pretty positive impact on those underserved associations who've been unable to obtain insurance previously. All right, so HB 14. This is a bill that is returning from the prior legislative sessions. I think not just the one in 2021, but prior to that as well. Now, this is related to property owners association fines. And this bill, if passed, would add section 209.0061, which will require property owners associations, only single family communities, to adopt an enforcement policy with specific provisions, including each category of restrictive covenants for which fines may be assessed. It would also have to include a schedule of fines for each category of violation, and also information regarding the hearing process provided for in 209.007, which you all are very familiar with. With this one, the association would also have to file that policy with the county clerk, which is not a new requirement, post the policy on the HOA's website, and then the only thing that's a little bit new here is to annually send a copy of the policy to homeowners within the POA. Now, many associations already have a policy like this in place because we frequently recommend it, and I'm sure any council would recommend that they have some sort of enforcement and fine policy if the association has the authority to assess fines or levy fines. Now it seems like it'll be a requirement, and it will require a lot more detail as well, because we will have to talk about the types of fines, the schedule of fines, and things of that nature. So it will be a little bit more involved, but this won't be too big of a deal because a lot of associations already have this sort of policy in place. Now, next we're going to talk about HB 330. This one is related to the association's ability to regulate residential wind power facilities by the association, right? So this new bill would target the use of renewable energy in communities. And if it's passed, it would add section 202.024 to the property code, and it would generally prohibit the association from adopting or enforcing an existing provision that prohibits or restricts a property owner from installing a wind power facility of an appropriate residential scale. Now, there are a few provisions within this bill that would allow the association to restrict the wind power instrument for, but here's the thing though, that's pretty vague. The ability for the association to restrict the wind power instrument, and then the phrase appropriate residential scale, those are all terms that really need to be defined, because that leaves a little bit too much room for interpretation, which we don't need. Also, for developments with fewer than 51 planned residential units, the declarant during the development period can prohibit or restrict a property owner from installing a wind power facility. We talked about this one in our bill spotlight that in the newsletter that we've sent out, but also during TLAC's rally day. This is one of the bills that we discussed with the legislators. As written, it's troublesome because, as I mentioned, it leaves a lot of room for interpretation and really leaves the association powerless to restrict wind turbines. If you look at the picture there on the slide, you can see those big, huge white wind turbines. It kind of reminds me of when you go, if you see a picture of Palm Springs and you have rows and rows and rows of those huge white wind turbines. I think about in my mind driving through a neighborhood and looking over and seeing this big, huge windmill, and it totally messes up the aesthetic of the community, for one, but also consider the other things like the noise, whether or not the homeowner will really maintain this thing. It kind of gives a little bit too much power to the homeowner in these sorts of situations. We really would like to see the association have a little bit more ability to restrict these. So as it's written, we don't love this bill, and hopefully we can get amendments to it. Hopefully it won't pass at all, but this would be applicable to both single family and condominiums. And that's actually really problematic in condominiums as well, because if you think about it, those are condominiums are sitting right on top of each other. Where would a person put it? On their balcony? Even with single family communities, if you're talking about like a townhouse or something like that, which there's very little space between each structure, it seems unreasonable that a person would be able to put up a large wind turbine like this, but we'll see what happens, right? All right, so this one is SB 468. It's related to the association's ability to regulate assembly, association, and speech of property owners or residents. It was referred to the State Affairs Committee on February 17th. It would add section 202.013 to the Texas Property Code. It also applies to both single family and condominiums. Now, this bill is also a smidge problematic. If it's passed, it would add, as I mentioned, Section 202.013 of the Property Code, and it would prohibit associations from adopting or enforcing provisions in their dedicatory instruments that restrict a property owner or resident from peacefully assembling or meeting with other POA members on POA common areas or inviting speakers, including public officials, candidates for public office, without prior approval from the association. They wouldn't need to ask for any, anything from the association, essentially. But these public officials or candidates for public office would be able to come onto common area and address or meet with members of the POA or their invitees. This bill would also prohibit the association from regulating or restricting the content of an owner's or resident's speech. The bill would not prohibit POAs from adopting or enforcing some sort of dedicatory instrument to the extent allowed by the Constitution that prohibits speech or conduct that threatens public health or safety, violates the law, or contains language, graphics, or any display that would be patently offensive to a passerby. So essentially, this bill is focused on First Amendment rights. Is protecting the First Amendment rights, essentially is attempting to protect the First Amendment rights of community members. But this is problematic as it's written because it leaves the association no ability to restrict the use of its own association-owned property or common areas. And also, if you think about it, if a person has, gone to the trouble of like renting out a common area, let's say a clubhouse or something like that for a child's birthday party, and then some other homeowner decides to have some event in the same clubhouse at the same time, that could create a lot of tension among homeowners. And then depending on what this other homeowner, has to say during this interruption of this child's party, that could just, cause a lot of trouble. There's already a lot of, fierceness and just kind of tension among homeowners right now anyway. A lot of us have seen this, when we have homeowners contacting us, a lot of people are upset. Even when we're doing our inspections of the community, you see a lot going on. So it's not necessarily the best idea to let people have free reign of the common area without, being able to adhere to some sort of schedule or getting the approval of the association before they're able to do that. Of course, there are exceptions, as I mentioned, things that threaten public health or safety, that violate a law or contain offensive language or graphics, but a lot of that stuff is subjective. And so it makes it very difficult for the association to be able to just govern its property in a peaceful manner. So we want to watch out for this one. All right, let's talk about HB 3775. This is really similar to the one that I just talked about. The only difference here is that the association would be able to enforce gathering to abide by the same rules as other gatherings held in common areas. So they would be able to impose fees, have a homeowner make a deposit, limitations on occupancy, hours, reservations, and things like this. So this one does give the association a bit more control over the situation, a little bit more ability to restrict these sorts of gatherings. But again, this is something that we just need to keep an eye on because it could be problematic. Again, these are things that are applicable to both single family and condominium associations as well. All right, so this one I think is actually really a problem, and I'll talk about the reason why in just a second. But HB 886 is relating to the requirements to file a property owners association assessment lien. So this bill, as it's written, would change the requirements for associations to file assessment liens against property owners. Now, I'll back up for a second. We're all familiar with the idea that the association's lien is already, or lien for assessments, right, is already created by the dedicatory instruments or by the governing documents, the declaration. And once the declaration is filed in the real property records, it becomes effective. So each property that's encumbered by the restrictions has a lien, right? But if this bill was passed, it would amend section 209.0094, which would require certain conditions before a lien could be filed. So it is essentially saying that a lien would need to be filed, which in our opinion, it doesn't, right? Because a lien is already contained in the declaration. But if a lien were to be filed, the association will be required to provide 3 separate monthly notices of delinquency by certified mail, return receipt requested, to the owner's last known address, according to whatever the records maintained by the association reflect, right? The association would also not be able to file the assessment lien before the 180th day after the third delinquency notice was set. So this is essentially adding 9 months to the collection process, which is absurd. As we all know, with the collection process, the first few days are critical. Most accounts are settled within that first few days. So this bill could really affect the association's financial stability. It affects its ability to collect delinquent assessments. And it just gives a lot more time to homeowners to, not pay their assessments. Those homeowners that we know are just kind of like dead set on not paying their assessments. This gives them a lot more time to just kind of, dilly-dally and not pay the assessments in a timely fashion. So the time period, the 9 months, is absurd actually, and we're hoping that this one doesn't get passed. And if it does, that 9 months would have to be reduced substantially to make this make sense for associations. Because at this current moment, this math is not mathing, and we're not happy with this one because it just kind of affects everything in general, right? All right, let's look at HB 1307. This one relates to the municipal release of ETJs and disannexation involving certain areas. Essentially, if this one was passed, it would add a section to the local government code, which would allow the majority of registered voters in an association that lies in an ETJ to petition to be released from the jurisdiction of the municipality and just have its own ETJ. So this one is one way or the other. This is not going to affect too much, but just something else to keep our eye on. All right, let's look at HB 1252. This one relates to the audit of financial records of certain POAs. So this bill, HB 1252, if passed, it's going to add section 209.00501 to the property code. It would require POAs to have an annual independent audit of the association's financial records, which is not so far-fetched, right? Associations frequently have audits of their financial records. There may not be an annual requirement, but this would impose such. But also, this bill would require the association to provide a copy of that audit to each member of the POA. So annually, after the audit is completed, the association would have to provide a copy of it to each member of the POA. Now, the audit would have to be performed by a certified public accountant if that's required by the association's bylaws, or if the board votes on that, or if the majority of the members of the POA voting at a POA meeting vote to have a certified public accountant complete this audit. The big thing to take away here is that it would require this copy of the audit to be provided to each member of the POA. That seems like a lot. Hopefully there would be some requirements in there that say that it could just be posted to the publicly accessible website that's required now. So we'll see. But as written, this one is a little bit cumbersome, and it adds another burden onto the association. All right, HB 1193. This one talks about housing discrimination, definitely prohibiting that by a POA as it relates to the tenant's method of payment. So this one is interesting because it adds section 202.024 to the property code, and it would make it so the association cannot enforce a dedicatory instrument. It can't adopt or enforce a dedicatory instrument that restricts or even has the effect of restricting an owner from renting a dwelling to a person based on that person's method of payment. And this one is actually geared towards or really focuses on Section 8 housing vouchers or any other housing or rental assistance or subsidy, because the definition of method of payment contained in this proposed bill actually specifically mentions Section 8 housing vouchers or rental assistance. So this would make it so that the association cannot prohibit tenants that are on Section 8 or have some sort of rental assistance. And again, this one actually applies to associations that are both single family and condominiums. And I thought this one was very interesting because, of course, it relates to prohibiting housing discrimination. It's one of the things that is mentioned in the Fair Housing Act. So this is just an extension of that into the association. Now let's look at HB 378. This one talks about preventing individuals from accessing private property for the purpose of registering voters or communicating political messages. This is kind of It's not exactly like the ones that I mentioned earlier that would require homeowners to gather onto community association common area without approval, but there's kind of an ongoing theme because that one also related to candidates for election, public officials and that sort of thing. But this bill actually would amend a section of the Texas Election Code, and it would prohibit an association from adopting or enforcing a rule that would prevent individuals from knocking on the front door of a residential unit, ringing the doorbell, or leaving a pamphlet, flyer, or other form of written communication for the purpose of registering someone to vote or disseminating support or opposition of a candidate or a party or some other measure. So this bill, it would allow the association to adopt reasonable restrictions, and those restrictions could be on the time, place, or manner of this activity. And actually, that's a great thing because we don't want someone to have a person campaigning at midnight, waking people up and that kind of thing. But again, this kind of bill or allowing this sort of thing without the approval of the association or something like that could be problematic. So as it's written, this one is a little vague. We would want to still have the association have its ability to restrict, self-govern, upkeep our property values and that kind of thing. So we will keep an eye on this one as well. This one is applicable to both single family and condominiums too. All right, let's talk about HB 328 and 329. These talk about the installation of solar roof tiles. We already have a section that talks about solar panels in section 202, but this is actually just procedural bills that clarify what solar energy device means under the tax code. It would not change existing law. It would just add another definition for the tax code. So this is not a huge issue, but still something that we wanted to mention. Now, HB 3423 and SB 1767 talk about the organization of meetings of and voting by condo owners and property owners associations. This would amend Chapter 82 to allow for virtual meetings and electronic voting, regardless of what the bylaws state. And then it would also amend Section 209.00592 to recognize electronic ballots as a valid method of voting. These are important because we all saw after COVID how important virtual meetings and electronic voting was. It's really just kind of the wave of the future. And so instead of us just kind of putting it in the bylaws and of course, that's still enforceable, but now the property code is just kind of recognizing the importance of both these things, virtual meetings and electronic voting. And they kind of want to just cement that in stone for us, which is a good thing. All right, HB 3064 talks about an association member's right to speak at a open board meeting or any sort of meeting. I will reserve commentary about this and let everyone form their own opinion, but HB 3604 would add section 209.051 to the property code, and it would require a homeowner forum at every association meeting, whether it was held in person, electronically, or by phone. Now, fortunately, this bill does contain some restrictions and some limitations. The association would be allowed to limit the time and manner in which the member is allowed to speak, but it can't impose restrictions that prevent the member from expressing their concerns. Now, the problem that I have with the way that this is written is that the manner in which a member is allowed to speak is a very ambiguous term, because does this mean that the member can get up and just start shouting, or they can speak in a bullhorn, or can the member stand up and sing a song that expresses their concerns? I'm not sure. So this, as it's written, is a little bit problematic. I would hope to see revisions of this bill so that we can understand what manner in which a member is allowed to speak means, and possibly even a revision to this in general, but that is what HB 3064 would allow. All right, now, the moment we've all been waiting for, let's talk about chickens. So as you know, there is a chicken bill nearly every legislative session. This time we have, I think it's more than 4 at this point, but essentially they are HB 276, 92, SB 326, and then HB 1191. You don't really need to remember these numbers because we're going to keep an eye on all of this for you. but I do want to talk a little bit about what each one of these means. So HB 276 would amend Section 202 of the Property Code, and it would prohibit the association for, this is for single family only, from adopting or enforcing a restriction that prohibited the growing of fruits and vegetables, raising of 6 or fewer domestic fowl, or 6 or fewer adult rabbits, and the production of food at a home-based cottage food production operation. With this bill, the association will be able to pass reasonable restrictions on the growing of fruits and vegetables on a single-family residential lot that don't have the effect of prohibiting the growing of fruits or vegetables in the front, side, or rear of a residence. The association can also pass rules or adopt rules that would have reasonable restrictions on the raising of fowl and rabbits. And that means that they could include a set number on the total number of animals allowed, or prohibit raising a rooster. They could impose minimum distances on the animal shelter from a residence. They could impose certain shelter requirements, sanitary restrictions, and then even the location to the rear or side of the residence. This doesn't apply to condominiums. It only applies to single families. I'll tell you all the problems that I have with these bills in just a second. I just want to go over what, briefly what each of them say. Now, HB 92 would allow for the same the prohibitions mentioned above, but it also includes one against the restrictions of solar or wind-powered energy devices, underground shelters, rain barrels, or rainwater harvesting systems, and also standby electric generators. HB 326 talks about the association's ability to regulate the raising or keeping of chickens, and proposes to add a section to the government code, which would say that there's only 6 chickens allowed on single-family residential lots. Now, of course, everyone loves the idea of having chickens on their property, right? And actually, that's the main focal point, right? It's really the animals, the chickens, the rabbits, and I think bees are also included in this one. But while public comments were largely in support of this bill, I really don't think that people are paying attention to the fact that this bill can be really problematic for associations. Now, first of all, it's too vague. There's a lot of details that are missing on the restrictions that the association could potentially implement. But even more so than the fact that the association can't really regulate this, it's the health and safety issues that really come to mind when you think about chickens and how gross they really are. During TLAC's rally day, we were told that there was a hearing regarding some of these bills regarding the chickens, and there was an expert from Texas A&M, their agriculture department, which basically brought up the fact that chickens really carry a lot of diseases. Avian flu is rampant amongst chickens, and that could potentially be spread to humans. So if you think about, that in and of itself, and then just the fact that we know that while there might be some homeowners that pay a lot of attention to their chickens, they might maintain their shelters and the area where the chickens are located, they're going to be just the same amount of homeowners that absolutely neglect the chickens, and they're going to have them running all over the community. The smell, the noise, just in general, this is just not a good idea. It could decrease property values. It could also, someone else brought up something that I didn't even think about, but chickens attract predatory animals like coyotes that could potentially be a danger to, other members of the community, small children, their small dogs, that kind of thing. And then also, if you consider the aspect of the food growing, which is not bad in and of itself, obviously, that it sounds great. It sounds great to have chickens so people don't have to pay $8 for a dozen of eggs. And it sounds great to be able to grow your own food, but consider someone having their garden in the front of their home and them failing to maintain the garden and the way that it looks. It's going to decrease property values. It's going to ruin the aesthetic of the community. And just in general, these bills are not really a good idea the way that they're written, because they don't give the association enough ability to restrict the chickens and the rabbits and the carrots growing in someone's front yard. So we're definitely going to keep an eye on these. Of course, I mentioned that all the bills have been filed. The deadline for that to happen was March 10th. That's passed. So we will just see how these move through the committee. Obviously, they were not passed last year. They weren't passed in years before that. But again, the price of eggs is high now. The price of food has gone up substantially due to inflation. So this is something that we really need to pay very close attention to. This slide has a lot of other bills of interest. There are things that we're keeping an eye on because they will definitely affect property owners associations if they're passed. We don't want to get into too much detail on these, but if we see that they're going to be passed, then we'll definitely keep everybody up to date and make sure that we are all informed, because that's really important. And then finally, there are still some things to come. Of course, the session is not over. I mentioned the important dates. We really still have until June 18th. The last day to file has passed, as I mentioned, so we shouldn't have any more surprises. Now we just have to focus and pay close attention to how things shake out over the next several months. And of course, we have CAI advocating on all our behalf, so we will continue to stay vigilant, and work diligently to ensure that our property owners associations and our clients maintain their ability to self-govern. We want to make sure that that remains intact, for as long as we possibly can, and to make sure that everyone, keeps their property values up. But honestly, we want to make sure that everyone just kind of like stays up to date with the laws and all that too, so that we are all, advocating for our clients and making sure that everyone's on the right path. So now I have a little time left over for questions. If anyone has any questions, you can put that in the chat. If not, I see a lot of questions in the chat, actually. All right, let me go to the top and see what I can. All right, is a portal with the management company with governing documents okay, or each HOA has to have their own? I recommend that each HOA has their own, because that says that the rule says that it needs to be a publicly accessible website. Now, I don't see the issue with, having a website and then having a link to each association on there. So that might be okay. But to keep things less complicated, maybe each dedicated website would be okay too. Let's see a question. Do you have to notice or solicit for ACC members if there are no positions open? The answer to that question is no. Regarding perimeter fences, does it apply to single family condominiums? I feel like they are sometimes in the middle gray area. So it applies to single family condos. Sorry, that threw me off. It applies to single family. I don't think that there can be perimeter fences in condominium aspects, but I need to take a look at that. But I think that rule really only applies to 209. So unless the community is governed by 209, it should not apply. Nick says 75% will never happen. That's true. So fencing, the front fencing is included in, was included in 1588. So perimeter fence means a fence around the entire perimeter of the lot. That's the reason why we needed to have some bills that clarified that, because we wanted to make sure that we were talking about, the build line, lot line, and the difference between the two. So that's why where the clarification comes into place. If signed by the governor in June, when will these become law? Is there a solid date or just when signed? So generally they will become law similar to like when they did last year, September 1st. So August 28th, I think is the date, but we can go with September 1st. So they will become law if they're signed by September 1st. Also, I thought perimeter fences were required to be permitted. Right, so by 1588, they were required to be permitted, but these new bills that I just mentioned are definitely adding some clarification to that. So we have to, they're required, but now maybe we can regulate them a little bit more as far as the size, type, height, and things of that nature. Let's see. Is in a single family home community, owners can put up a front fence around their yard? Yes, they can. Yes, we will. A copy of the slides will be available, but also we were recording this, so we will be putting it on our website for future reference. Let's see. Currently, 209.017 allows for an action to be brought in JP court for a violation of 209. What are the current remedies available to the owner besides recovery or fees? That's what the remedies are, essentially, recovery or fees. At this time, I have not seen any cases that dealt with that. George asked this question, but essentially the remedy is recovery of fees and not much else, honestly. The notice requirement is insane. Yes, that's absolutely true. Would street parking include 18-wheelers? So it seems like that's kind of what I was talking about, Melissa. It seems like street parking might include 18-wheelers if they fall under those provisions that I mentioned, right? If they are related to a person's employment, or if it's an emergency vehicle. I don't see how an 18-wheeler would be an emergency vehicle, or if it was a state vehicle, then it's possible that 18-wheelers could fall underneath that bill that I just talked about. How would an HOA set standards for proof of these vehicles? Yeah, it is going to obliterate the street parking restriction. So we might have to put something in place where a homeowner would have to provide proof that the vehicle was either a state vehicle or it was related to their employment. Would the city override HOA governing documents? Still, yeah, in general it would, but these are state laws. So the state laws would override the city laws. So we would have to go with the state laws. If the HOA doesn't have an enforcement policy in place, can it be added without a majority vote? Generally, depending upon what the language is in the bylaws, the board can adopt a policy, but we have to look at what authority it has in the declaration, what authority the association has in the declaration. Does it have finding authority? Does it have the authority to create rules and regulations or adopt policies? That's the sort of thing that you have to consult directly with your council about, because that's going to be on a case-by-case basis. Let's see. A lot of these bills would be allowed for reviews and revisions, and so hopefully some of them would be revised. Hopefully, that's kind of one of the things that we were advocating for during TLAC, is just some of the bills as written would not be beneficial to property owners associations, and in fact, they would strip the association of their ability to self-govern, that kind of thing. So we're hoping that we'll get some revisions here in the future. This 38. I have to go back and take a look at what 378 actually says. Sorry, I can't think about it. The chicken bill would override a city ordinance. Yes, it would. Let's see, what else? We will send out the information. Andre will make the presentation available to everyone. Yeah, Eve, the question Eve asks is, do you anticipate that the proposed bill would allow legal action against a board member to raise D&O and GL insurance rates? Yes, I do. What about an HOA that has a voluntary membership and non-active board? How would they be regulated? That actually would depend on certain things like how many lots you have, so on and so forth. So that's a question that we would have to look at on a case-by-case basis. Again, yes, the information will be available to everyone to get a copy of it later. Let's see. In the city of Houston, vehicles may only park on the street for 24 hours without being moved, but it sounds like this bill is meant to deal with chronic regular parking by owners. How can an HOA regulate rules parking not on private property? Wouldn't local and state laws prevail? Right. So what we're talking about today, again, these are state laws, and so these would definitely prevail. So it would kind of maneuver how an association is able to regulate rules and parking. So if this bill is passed that allows these regulations against street parking, then the association would have to abide by what these rules say. Would homeowners expect to be accessible anytime, or what type of accommodation is the POA expected to provide if SB 648 passes? So hopefully SB 648 doesn't pass, but its companion bill would allow some restrictions as far as time, fees, occupancy, and that sort of thing. So hopefully that one would help us out a little bit. Yes, the parking bill is problematic. Absolutely. I think so too. Let's see, if the chicken bill passes, would the POA be allowed to put restrictions on where the coop was built, of what material, fence, whatever? We certainly hope so. That's one of the things that we talked about when I mentioned that as written, the bill was too vague and didn't give us enough ability to restrict. Some of the companion bills do add the association's ability to restrict where the coop goes, distance from other residences, that sort of thing. So hopefully the one that has a few more restriction, the one that gives the association more ability to restrict is the one that will get passed. Is a voluntary association subject to these bills? It depends on whether or not it's a 204 community, if it's subject to Chapter 209, that kind of thing. So that's a question that needs to be answered on a case-by-case basis, because I would have to actually look at the governing documents and that sort of thing. All right, so that looks like all the questions that I have. And yeah, so that looks like all the who determines the occupancy number in the clubhouse? The fire marshal. Yeah, but also if you have a policy, you would put that in there to make sure that it states what the occupancy would be. And of course, if the bill, the language provides a, certain occupancy limit, then that's something we would have to take into consideration too. I don't really foresee that because there would be too many instances. It depends on the size of the clubhouse and where it's located and that kind of thing. But we would definitely need to make sure that we have a policy in place that states, this is what the occupancy limit, and then maybe even post it in the clubhouse. So that's all I have for everybody. Thank you for all of your questions. Thank you so much for your attention over your lunch break. I appreciate you guys. If anybody has any further questions that I wasn't able to get to today, don't hesitate to reach out to me. My email is nhicks@rmwbh.com. Again, the presentation and I believe the slides will be posted for you guys to reference later on. So have a wonderful day. We will continue to put out more information as we get it. To keep everybody updated, because we're staying pretty on top of, we have a dedicated attorney that's staying on top of the various bills and how they're moving through the committee. So you guys will be updated. You'll be educated just along with us, because we want to make sure that we all know what's going on with this session. So thank you guys once again, and I hope you have a wonderful rest of your day.